One of the most frightening and confusing parts of any Minnesota DWI case is the court process. Most people who are charged with a DWI have never been to court before and certainly have never been charged with a crime. Now you find yourself having to answer to the charges, and if you're like most people, you wonder what's going to happen. A courtroom can be a very foreign and confusing space if you're not used to it and you don't know the rules. In Minnesota DWI cases, there are several sets of rules and several sets of customs that a person will need to know or their attorney will need to follow to get them through. There are rules of criminal procedure that apply throughout the state. There are rules of evidence, and then there are also local and city rules that apply, and even different rules from different courts. For example, one court in a county might have different rules than another, and even within a single court, different judges may have different rules and expectations for the case. When you're first arrested, the first decision that will need to be made is when you are going to be released from custody. Now, in most Minnesota DWI cases that are misdemeanors, first offenses, and so forth, you can be released on your own recognizance. That means you get released with a promise to come back and appear in court for your next hearing. In other cases, it may be required that you post a bond. If you can't post the bond, then the court will hold you in jail until the time of your next hearing, which will be your arraignment. When a bond is posted, or when a judge goes to make a decision about whether you should be released or not, or whether bond should be required or not, certain factors are taken into consideration. These factors are called aggravating factors. So, for instance, if you have a prior DUI charge on your record, if you have a case that involves an extremely high level of alcohol, if you have a injury or death involved, or a history of failing to show up to court, the judge may decide not to release you without requiring a large amount of bail. When you get to your first hearing after your release, it's called an arraignment. The court will basically tell you what you're charged with and ask you to formally enter a plea. That plea can be either guilty or not guilty. If you plead guilty, you'll proceed to sentencing. If you plead not guilty, then the next hearing, which is a pretrial conference, will be scheduled. At the pretrial conference, you'll have an opportunity to update the judge on your case. Your attorney will do this for you. You'll also deal with scheduling issues, such as when the next hearing will happen, and discovery issues, such as is the prosecutor giving your attorney the information that he or she needs to investigate the case, and so forth. At that time, the prosecutor may offer you a plea bargain in which you would enter a plea of guilty to the DUI or to a reduced charge in exchange for not litigating the case. If this doesn't happen, then the case can get set for trial. Before trial, there may be a pretrial motions hearing. A motions hearing is where a judge decides certain legal issues in your case. Most of those legal issues are raised by the defense, including motions to suppress chemical evidence, field sobriety tests, and so forth. If a defense attorney can knock out certain evidence against you, the state's case may fall apart and you may be offered a plea bargain that's better than the original DUI that you were charged with. At the hearing, a police officer may be there to testify, and your attorney may get a chance to cross-examine him or her. The judge will then rule on the issues and decide whether certain evidence will be admitted or not. If your case proceeds to trial, it will likely be in front of a jury of 6 people. The jury will decide your guilt or innocence. The prosecutor goes first in the case, then your defense attorney, and you'll get the chance to testify if you want to testify, but the state can never, ever compel you to testify if you do not want to take the stand. After the trial is over, if you're found not guilty, then your case is over. If you're found guilty, then you would proceed to sentencing. You would also have a sentencing hearing if you plead guilty. So if you accept a plea bargain or you lose a trial, you go to sentencing. And at the sentencing hearing, the judge will tell you what your punishment is. You and your attorney have a chance to attempt to influence the judge's decision as to your penalty by talking, and you can make a statement when you're in court. You also have the right to appeal if you go to trial and you lose. And you'll need to make sure that your attorney understands that you want to appeal and files the appropriate paperwork on time. If you're successful on appeal, your guilty verdict can be overturned, or a judge's ruling that led to that guilty verdict could be overturned, and you could win the right to a new trial. The Minnesota DWI court process is a complicated thing. To get more information, visit DWIattorney.com/Minnesota/MN-process and contact a local DUI lawyer in Minnesota to discuss the case and how it relates to your specific life circumstance and the facts.